Good afternoon and welcome to today's webinar, which forms part of our 2023 Managing for Success series. I am James Wright, one of the DG Legal's compliance consultants, and I'm joined here today with my fellow consultant, Sarah Charlton. For those of you who haven't joined a DG Legal webinar before, the slides and the recording from today's presentation will be sent over to you tomorrow. We're currently in webinar mode, so unfortunately you won't be able to see or hear any of you. Please use the Q&A function if you have any questions. Alternatively, use the chat function for anything else. The training should last no longer than 20 to 25 minutes to ensure that there is time to answer any questions that you might have. So we appreciate this is the main advantage of attending a live session. So just an overview of who we are. Sarah has a BSc Honours in Applied Accounting and is a fellow member of the ACCA. Her career spans over 35 years working in the legal sector. During this time, she has worked with a number of legal regulators, professional bodies, and government organisations. Sarah is also an executive member of the Institute of Legal Finance and Management. My career in legal finance spans over 25 years, working mainly in medium to large law firms, managing their legal finance functions. My knowledge and experience has enabled me to provide extensive support to law firms and their COFAs, helping them build processes and systems to ensure compliance. So let's have a look at today's session and what we're going to cover. During today's session, we will look to consider what risk is, how you might be able to identify risk, and in turn, what your options might be in managing that risk. So accept the risk, avoid the risk, reduce the risk, or transfer the risk. Sarah, over to you.
Brilliant. Thank you very much, James. Apologies in advance for delaying this session for a week. That was me. I haven't been 100%, so hopefully my throat and my voice will hold out for the next 20 odd minutes. So let's have a look at what risk is, and I would sort of, sort of broadly speaking, it's a term that's used to describe the possibility of a loss from something happening or not happening, as the case may be. I just want to emphasize, though, the latter point, that it might not be because your action has created the loss, because that's what a lot of people see risk as, something that's an event that's happened or a situation that's occurred, but instead you might have actually omitted to do something. So you should consider both angles when you're thinking about risk and not just look at it from one side. The reason why I wanted to emphasize that specific point is because a lot of law firms who do actually make an unconscious decision by the fact that they have avoided or delayed making any decision at all. You've still made a decision not to do anything. So it's easy to be lulled into a false sense of security, that things will stand still if you don't do anything. And that can range from there being a new HM Land Registry portal, leaving it until the 11th hour to make the changes because you don't want to make change, or it can be something a little bit bigger than that, like artificial intelligence. I know a lot of law firms don't have an appetite to look at it. It's something that they're going to consider when they have to. But it's rarely the case that any good comes out from sort of digging your head in the sand. One of the things that I really liked, quotes that I really liked about how AI might actually impact the legal profession, is that tech won't replace lawyers, but instead law firms who use tech will replace lawyers. So if you decide to do nothing, just be aware that that is a conscious decision that you're making. Firms manage risk all the time without even realizing. So two examples that spring to my mind are making good business decisions. So that's one way that we manage risk on a regular basis. A lot of your senior managers, middle managers will manage risk on a daily basis without even thinking that they're, it's just something that they do and incorporate in their decision-making process. So another example is having skilled finance staff to manage the firm's finances, or a knowledgeable accounts department to be able to manage the financial compliance. So there are ways that we might manage risk, but it's the chance or probability of something happening or not happening. So a really good starting point, I think, to consider for law firms is operational risk, because that's probably something that's going to touch most members of staff. Some of you may have seen in the press more recently that the property sector has been impacted by IT issues, and that has resulted in completions not taking place. IT is something that we use on such a regular basis. It's integral to the operations. So thinking about how you can maybe reduce that, avoid it, or minimize it, as James has alluded to already, should be something that you should be considering in a more formal, structured process rather than sort of regular day-to-day decision processing. We've also seen more and more firms grappling with financial risk. James and I deal a lot, obviously, in the financial side of things, and borrowing has become more expensive. So there is a real risk of people running out of working capital. The government, a lot of the sort of bounce back loans and things like that, they have had to sort of largely be repaid by now. So things are becoming a bit tighter. There's less work around as we hit the recession. So working capital is going to be a risk. So if it wasn't on your risk register, it definitely should be something that you should be looking at. I would also say that compliance risk is something that's missed off the list. But ultimately, you are only as strong as your weakest link. So you might have 90% of the firm particularly compliant, but you only need to have one weak link for it all to fall down. More recently, I'd say over the last 10 years, succession planning has become more and more of a strategic risk, as more and more associate solicitors who are on a decent salary aren't finding the sort of model of partnership particularly attractive. Why would you want to have all that stress and additional worry just for an extra 5 grand or 10 grand or 15 grand? So they're not attracted by money in the same way that maybe, or kudos status, as other people were 10, 15 years ago. And through that, we are seeing an emerging trend of employee ownership trusts. But that again relies on the employees, the staff wanting to embark on that model. So I'd say that succession plan is an issue for a lot of law firms, more now than maybe over the last 5 or 10 years. Then finally, I'd say reputation risk is again something that's relatively new. And that's because more and more law firms now are looking to compete with, well-known brands. And when I say that, most people are sort of thinking about the Magic Circle law firms, but that's not necessarily the case. So I'm part of a smaller law firm in a local area. So our brand against other law firms is quite important. How ethical we are, how we treat the environment, all those sort of things start to build our reputation. So you only need to have an incident like employee theft, and especially in a smaller location, that goes around like wildfire. And obviously there are going to be challenges on how you actually manage that and how you mitigate it. So I love a little bit of audience participation, as anyone who's already been on one of these series will already know. So please warm your fingers up and have a think about what operational risks you can think of outside of the one that I've already given you, which is IT. So just take a couple of minutes, and then James is going to go through some of the answers that we've had to think and consider how they might impact a law firm. Please don't be shy. I'm sure there's got to be some people with some views or opinions. Okay, so we'll just move on because we are going to touch on some of these, some of the risks that might give you some inspiration of other risks. So once you've identified the risk itself and the types of risk, we can then move on to consider how we might be able to manage this. So it's quite common to capture risk through the use of a risk matrix. And this allows you to consider the probability of the risk and the subsequent impact of that loss. And it's commonplace to use a 1 to 5 numbering system as indicated in this diagram. And as James has alluded to, you will have access to the slides, so you'll be able to have a look at it. I thought it'd be useful if I just produced a very, very simple matrix that allows you to have a good starting point if you've never used one of these before. Some of you will be in medium-sized law firms who will already have an established risk matrix, but a lot of you, I suspect, will be in smaller firms where this is quite a new topic, and especially the use of a risk matrix. So I've used the risks that we've already discussed to demonstrate how this works from a practical perspective. But hopefully what you will have spotted is that there are actually sort of two columns. So it's good practice to consider what your current risk is and what risk might be, might be able to, what changes you might be able to put in to be able to mitigate it and reduce it. So you'd use the notes section. So if, for instance, on the succession planning, you had hired somebody and you were expecting them to become a director in a year's time, then you would sort of, maybe your current risk might be 4 or 5, because at the moment you're a sole practitioner, you only have one partner, but you'd hope in another 12 months' time that risk might go down to 3 or down to 2. So use the notes section just to sort of put some substance on what you think is going to change or how you're going to be able to manage that risk to take it from one indicator down to another indicator. Another term that James and I use on a regular basis, and it's one of my favourite terms, is about risk appetite. So law firms, it can vary a lot between law firms. So you have, like I said, James and I do a lot of financial compliance. So you have some law firms who will want to apply the accounts rules to the letter and as close to the letter as they possibly can. However, you've got other law firms who are more risk adverse and will want to have a greater distance, a greater space between what their procedures are and where the where the letter of the rules end. So depending on your risk appetite will depend where you might sit. And I thought this was quite a good diagram to sort of highlight that you might have some law firms who might want to go at a steady speed of 40 miles an hour. They want to have that buffer of compliance and that headroom before they actually sort of start to have some serious consequences. However, in contrast to that, you may have firms who have quite a healthy, ambitious appetite for risk, and they are looking to drive, the business at 70 miles an hour, pretty much across the whole business. There is no right or wrong. Obviously, if you're driving the business at 70 miles an hour, there's a greater probability that something is going to come up and bite you, but there isn't a right or wrong. You could also argue that driving it at 40 miles an hour is so slow that you're missing opportunities and you will be left behind. So both could result in firm closure, but for different reasons. So have a think or have a conversation with your business owners, or if you are a partner, it's really important that you share with your managers what your risk appetite is. So anyone who is on the front line making those day-to-day decisions is aware what your risk appetite is. So I've got this this particular scenario, but I think should we stop, James, just for I can see there's something in the chat. Did you want to share?
Yeah, absolutely.
What's in there?
So it's going back to your earlier question about potential risks, and this one is a phishing scam. It's a good one.
That's a really, really good one. Yeah. So that's a greater risk, isn't it? Cybercrime and things like that. And there's talk about cyber criminals using AI to be able to circumvent and, be more intelligent and targeted when they're actually doing those phishing attacks. So, so yeah, really, really good one. I noticed we have a second one there as well.
A second one, yeah. Toxic work environment and an incapable line manager.
Well, unfortunately, that does happen. that feels quite a passionate statement. So I'm guessing that might be where you are at the moment. Yeah, unfortunately, lawyers, going back to one of my earlier statements, many solicitors can be driven to sort of avoiding those difficult decisions. And at the end of the day, you risk losing really, really good people. And losing really, really good people is an operational risk, because if you don't have a great team, then you can't really deliver a great service, can you? One person can never deliver a great service 100% of the time. However, a team can. So yeah, that's a really, really good one. I like that one.
Yeah,
Toxic.
I think
Two really good, yeah.
Yeah, and so another one, conflict of interest checks not being done and notes not being recorded on files.
100%, and another really, really good operational risk,
Yeah,
and compliance risk. So it touches on both of those. So if you were a business owner, you would have to try to sort of think about how can you stop that case progressing without a conflict. So you can change that to be a mandatory requirement before a file comes out of onboarding. So there are mechanisms that you can put in if you choose to put those mechanisms in. And then in relation to, sort of file craft is something that I like to use really to talk about good housekeeping as well as well-written notes, comprehensive notes. And I think that that can be, again, a mechanism you can use is, the appraisal process and, performance reviews to make sure that they realise that they're not going to get their bonus or they're not going to get some of the things that they may want by not by not being diligent, because ultimately, again, it can impact the rest of the team. If they're off sick and you've got another team member having to pick up their work, it's really not fair that they're not only having to pick up your work, but you've made it so difficult for them. So it's really not fair to be able to do that. But the main thing I want, I think there are three really great examples. So really happy with that. But you can see there are solutions if law firms choose to go down that route. And again, by doing nothing, that is a conscious decision that they've made. So, James, are you all right to read out this sort of scenario for me?
yeah, sure. So you are a small law firm with 10 solicitors who have all been practicing for 5 years or more. You have 3 offices. You have a property department consisting of 7 qualified solicitors/lawyers and a private client department that has 3 solicitors, lawyers. It's your intention to start taking on family work. What risks might arise from this decision?
So ideally, we're looking for ones that haven't been mentioned. So we wouldn't be looking for the cyber one, or have a think about um, what could the firm be exposed to. So I'll give you some helpful clues. There's nobody there that knows family work.
Yeah, big risk there.
And it could be a case that perhaps, everyone else is already at capacity.
Mhm.
And then from a sort of indemnity insurance perspective, how do you think the insurance renewal might go when all of a sudden they're doing a new category of law?
Yeah.
Well, by all means, take a couple of minutes to ponder, because we've got another slide or another interaction a little bit later on. So if you do think of something as we're going on, please do pop it in there, because it's great to be able to give that benefit of advice and steer on a live session. So James did talk about the fact that there are different ways of managing risk. So we've talked about what risk is, we've talked about how you can identify it, we talked about how you can manage it. So going into a bit more detail on how you might be able to manage it. Something that a lot of law firms do is consider transferring the risk. So that's generally a contractual arrangement where one party who doesn't wish to have the risk and there's another party who is willing to accept that risk. It's usually for a premium. And a common example of this is actually insurance policies. So whether that's a business interruption policy, whether that is a buildings flooding policy, whether that's professional indemnity. If you work in practice, especially in the property department, you regularly might take indemnity policies if there's a defective title in a property transaction. So there's various different reasons why you might take insurance out, but it's all about transferring the risk. So you're only at risk based on any excess. So if your professional indemnity is 2 or 3 million and you do a 4 million transaction, then obviously you accept the risk of that extra £1 million if you haven't gone out and bought top-up insurance. So transferring risk is something that we're all very, very familiar with. But unfortunately, some risks can't be avoided just by the nature of the work that you do. But it can instead be reduced through various different controls. An example of this is an employee leaving, going to a direct competitor. So one of the ways that you can reduce that risk is actually putting in their employment contract a clause that prevents them from working yay amount of miles within your particular business for a given period of time. That doesn't remove the fact that the person is going to leave. That doesn't change that. But what it does is it does go some way towards mitigating or reducing the impact that that might have, their departure on your particular business. I would say, though, that the clauses do need to be well worded. And if you do have competition clauses like that, you might want to actually go back and revisit them, because a lot of people homework now. It makes it a lot harder to define the distance from an office, because it might be a case that they only actually go there 1 day a week. So to sort of circumvent the competition clause, it might be a case that they've been allocated an office 100 miles away, where in reality they're actually working sort of just down the road and possibly seeing clients at their home or local home visits, signing documents and things like that. So do have a think about it if you do already have a competition clause, that you might want to revisit the wording. For those of you who don't have competition clauses in, again, it's one way that you can actually reduce the risk of your sort of prize pony leaving and going to another law firm. Okay. Some risks can be avoided to remove the exposure completely. An example of this is where maybe, for instance, you use a third-party provider. So something that James and I come across quite regularly is outsourced legal cashiering, or you might have outsourced secretarial, typing services. So when you're outsourcing something, there is obviously going to be a risk, because you lose control over a lot. Well, you lose control largely over the task. And whilst you can actually put in a sort of service level agreement to sort of say you need to return it by this, you're still going to be concerned that that supplier has to manage the wants and needs of not just you, but also other competing clients. So you may find that there is a risk there that could be avoided just simply by bringing that back in-house. And it means that you can prioritise the cashiering, you can prioritise the typing services, and have that control. So that's one example of how you can sort of avoid something. So I did say lucky, lucky, lucky that you would have one final audience participation. So I can see there's a question, James. Did you want to?
Yes. Yeah, absolutely. It's a good one. You're a small firm, solely practicing immigration or family law. You decide not to open a client account and have only one office. What risks might you be aware of about this model of operation?
The first thing that springs to mind is the fact that you don't have a client account. So if something does occur where you need a client account, then obviously there is a risk. One of the ways that you could look to mitigate that, having a client account itself and not using it doesn't trigger an SRA accounts rules reporting requirement. So if I was in your shoes, I'd have a client account, even if it was dormant for 10 years. It's better to have it and not need it than to need it and only have 24 hours to actually try to open it. That was my initial view, but I'll pass you over to James, because I'm sure
Yeah.
he'll have some others.
So one of my first thoughts was, do people fully understand the requirement of not having a client account? So quite often firms don't understand the kind of niche area of making sure that when you're receiving money account of disbursements, although it may not have been paid yet, it needs to have been incurred. So my concern would be sort of on the immigration side of things, if you're taking money in advance on account for home office fees, you should hold those in a client account unless you've already incurred those fees with the home office, which quite often firms wouldn't take the risk of doing that. So ultimately means that they would actually need a client account.
Good call. That's another that I wish that I'd thought of that.
So they said immigration or family law. So just thinking about family law. So I guess
Family would be the same, because you have a petition fee and you have a degree absolute and things like that. So you might have them in advance, but not having incurred them yet because you haven't submitted any of the forms.
Yeah. I think it's such a niche area that firms still don't fully understand the unpaid disbursements element of it. So that's, I think, a key takeaway. Not sure outside of those two points that we've picked up.
Yeah, no, that's good. So then let's have a look at the final audience participation. So just to give us a sort of benchmark of where you think your law firms are from a risk appetite perspective, are you able to just pop in your chat to sort of maybe either let us know if you have no idea, because then that means that that's something that's not being disseminated by the partners, or if you do know what their risk appetite is, it would be really interesting for us just to have a flavour of where people might sit on that sort of 40 miles, 70 mile an hour radar.
So it looks like we've got some more. So I think it just goes back to the discussion that we've just had a minute ago about someone's responded saying, a family legal aid firm, I closed the client's account 5 years ago, sent residual balances to the Solicitor's Benevolent Fund. Is there some more guidance about this, as they've now raised my concern? Sorry, I don't really understand your risk appetite section.
That might be good, maybe just to email in, and then James and I can take it offline for you, because I think that there's quite a bit of advice that we would need to give you on that one. So if you want to email the DG Legal Office, they'll be able to put you in contact with us, and we can give you some very specific advice. But there isn't a quick answer to that. There's a couple of things that we'd have to cover off. So anybody want to share their firm's risk appetite with us? Okay. So the final stage really is just to sort of to summarize really that risk is all around you when you're in business, and it doesn't matter what your role is. There's a risk of a violent client coming in. There's a risk of pandemic. There's a risk of people not being qualified to be able to do the work. There's a risk of people being overstretched. There's a risk of key staff leaving because poor behaviours haven't been dealt with. The risks are all around us, so it's just a case of being more conscious about it after today's session, I'd hope. The earlier you can identify the risk, the better placed you're going to be able to manage it, and hopefully reduce it, avoid it, transfer it, however you need to deal with it. But the earlier you can capture it, the better placed you will be for doing that. So with 60 seconds to spare, you'll be pleased to know that that's the end. Thank you very much for sharing 30 minutes with James and I, and we hope that you've enjoyed it, and have a lovely afternoon.
Thanks all.